Hi, welcome back to the 360 Solicitors microcast. The album is called How the Law Works in Nigeria. This is episode 9 and it's titled Islamic Law in Nigeria. I am Ishaq, a Nigerian lawyer. You can call me Shola for short. I'll be right back. Nigeria is often divided into north and south. Islam entered Nigeria from the north, and after the establishment of the Sokoto Caliphate in 1804, Islam became widely adopted as a religion and the Sharia became the dominant legal system in most northern societies. The implication of this was that the public and private affairs of those northern societies were organized according to Islamic law. Meanwhile, at the same time in other parts of Nigeria, the customary law of each ethnic group or town governed the public and private affairs of their peoples, even though Christianity has started to make inroads into southern Nigeria. That was all, of course, before colonization. In recognition of the roles played by Islam and the Sharia in northern societies, the Nigerian Constitution gives limited recognition to Islamic law. That recognition is limited to Islamic personal law, that is, the type of Islamic law dealing with marriage, divorce, custody and guardianship of children, family life, inheritance, trust and endowment, etc. Do other types of Islamic law apply in Nigeria? The answer is yes, but we have to be very careful in saying so nonetheless. Because Islamic law was to many northern societies what customary law was to many southern societies, it is possible for two consenting parties to adopt Islamic commercial law for purposes of their business transactions. In fact, many people in the Muslim-dominated parts of the north had been doing this. For example, with the Islamic cooperative societies, even before the formal introduction of Islamic banking and finance into the Nigerian banking system in 2011. Islamic banking and finance law was introduced into Nigeria in 2011 when the Central Bank of Nigeria licensed Jaiz Bank PLC as a non-interest commercial bank operating on the principles of Islamic commercial law. The legal principles of Islamic banking and finance laws are derived from the general Islamic commercial law. It is important to note that if you are not a Muslim, Islamic personal law does not apply to you unless you choose it by marrying under Islamic law. Even if you are a Muslim, you can choose not to be subject to Islamic personal law. All you have to do is to get married under the Marriage Act instead of under Islamic personal law. Whether you are a Muslim or not, you can choose to complete your business transactions in accordance with other types of law instead of Islamic commercial law. Don't forget, it is your choice to do business with an Islamic financial institution like banking with an Islamic bank or taking out an insurance policy with a Takaful insurance company. So now you know both Islamic personal law and Islamic commercial law can apply in Nigeria. Is there any other type of Islamic law which we have not talked about? Yes, the controversial Islamic criminal law. You see, just as customary law crimes were enforced in the areas now known as southern Nigeria before colonization, so were Islamic law crimes enforced in the north. However, under the present constitution, an action or an omission is only a crime if an act of the National Assembly or a law of a State House of Assembly or subsidiary legislation has clearly stated that act or omission to be a crime and also stated its punishment. This is why in episode 8, the court said Mr. Awoko was not guilty of adultery because adultery was only a crime under customary law but not under legislation. In other words, if legislation says adultery is a crime, then it is a crime only because legislation says so and not because customary law says so. Now, let us apply this logic to Islamic law crimes in Nigeria, and you should not jump to conclusions yet. On their own, Islamic law crimes cannot be enforced against anyone in Nigeria, not even against Muslims. But what if Islamic law crimes and their punishments are clearly enacted into an act of the National Assembly or a law of a State House of Assembly? In fact, that is exactly what the National Assembly has done in some parts of the Penal Code Act, which applies only in the FCT Abuja, and exactly what some northern state houses of assembly have done in their general penal code laws and their controversial Sharia penal codes. The question, however, is that since these crimes are now in legislative enactments, can we still call them Islamic law crimes, or are they simply crimes under legislation? Well, you know the answer of the northern states, but some people say they are still Islamic law crimes. Why? They say since the constitution forbids direct and indirect adoption of a state religion, Islamic crimes legislation is therefore a way of adopting Islam as a state religion. They also say since the Constitution forbids discrimination on the basis of religion, and since some of those crimes apply only against Muslims, they are therefore discriminatory against Muslims on grounds of their faith. The truth, however, is that the jury is still out on this issue. Before I go, don't forget, nothing in our podcast is legal advice. Our podcast is for educational purposes only. If you need legal advice, please consult a lawyer. If you like the episode and subscribe to the channel for more, you can follow us on Twitter, Facebook and Instagram. The handle is @360solicitors or @Shola for short. See you in the next episode.